Hello, good afternoon, everyone. Myself, Vipin Bhati, Assistant Professor, IIMT College of Law. So, hope all you are very good. So, now the topic for discussion is the Constitution of India. So, all of you are know that the Constitution of India is a pious law of Indian legislature. So, I think everyone knows about the provisions of the Constitution of India. So this is the introductory class. In this class, we have discussed the salient features of the Constitution of India and what are the characteristics and what are the nature of the Constitution of India. So first of all, so what is the nature or what is the status of Constitution of India? So first of all, Professor K.C. Ware has said that India is a quasi-federal system. India is a quasi-federal system which is similar to a federal system. So there is, because it has some features of federal and some of unitary constitution. So basically, this have quasi-unitary features and quasi-federal features of the nature. So we can say that it is quasi-federal. Okay. So when we are talking about the provision of unitary, so in Article 1, and there are so many provisions like appointment of governors, president provisions. So all these are so that Constitution of India is in nature is unitary. Because, for example, provision regarding president. So the president is the head of the union. President is the head of the union. So पूरा एक देश है इंडिया, तो उसका एक ही हेड होगा. एग्जीक्यूटिव हेड कौन होगा? प्रेसिडेंट ऑफ इंडिया. सो दिस शोज दैट the nature of the constitution is unity. For example, when we are talking about the federal nature, so there are some provisions. For example, Article 245 says that there is separation of power between center and states. And one more example with this, Schedule 7 of the Constitution of India also. So in the Schedule 7, there is three lists. One is union list, second is concurrent, second is state list, and third is concurrent list. So these lists are shows that the domain of the different heads. For example, the union legislature makes the law only for the matters which is given under the union list also, and as well as the state legislature makes the law in regards only the state list matters also only. Okay? And the third is concurrent list. So the matter which is given under in concurrent list. So on these matters, both central or state legislature can enact the law. So this was the federal character of the Constitution of India. वहाँ पे क्या फेडरलिज्म, वहाँ पे क्या लेजिस्लेशन का बंटवारा कर दिया. यूनियन गवर्नमेंट, सॉरी यूनियन लेजिस्लेचर यूनियन के लिए लॉ बनाएगा, ठीक है, जो यूनियन लिस्ट में दिया हुआ है लिस्ट 1 में, और स्टेट लेजिस्लेचर स्टेट लिस्ट के लिए बनाएगा जो लिस्ट 2 में दिया हुआ है. सो दिस वाज द फेडरल. ठीक है. तो दिस इज द फर्स्ट डेफिनेशन ऑफ प्रोफेसर केसी वेयर. ठीक है. So the our maker of Indian Constitution, everyone knows, Dr. B.R. Ambedkar also defined the nature of the Constitution. So Dr. B.R. Ambedkar, Bhimrao Ambedkar says that it is a federal constitution, although the center has a certain powers to override the provinces. डॉक्टर भीमराव अम्बेडकर क्या कहते हैं कि ये फेडरल कॉन्स्टिट्यूशन है, यद्यपि इस संविधान के अंतर्गत बहुत सारे प्रावधान ऐसे हैं, बहुत सारे प्रोविजंस ऐसे हैं कि जो प्रोविंसेस की जो हमने लेजिस्लेटिव पावर दे रखी है उसको भी ओवरराइड कर सकते हैं. ठीक है. तो ये प्रोविंसेस वर्ड यूज किया गया है कि उस टाइम पे एट द टाइम ऑफ इंडिपेंडेंस प्रोविंसेस थे, रियासतें थी, बाद में वो जाके स्टेट बने, हमारा स्टेट ऑर्गेनाइजेशन एक्ट किया है, उसके बाद बहुत सारे स्टेट उसमें ऐड हुए, ठीक है। तो बी आर अम्बेडकर बोलते हैं कि भारत का जो संविधान है वो फेडरल है, लेकिन यहाँ पर कुछ ऐसे प्रावधान भी दिए गए हैं हमारे संविधान में जो जिसमें कि सेंटर को पावर है कि वो स्टेट वाले को ओवरराइड कर सकता है, ठीक है। अब फॉर एग्जांपल आर्टिकल 247 दिया हुआ है, तो उसमें क्या लिखा हुआ है, 247 हमारा क्या बोलता है, यदि देयर इज एनी रेपुग्नेंसी, सॉरी 249, if there is any repugnancy between the laws made by the center and laws made by the state, then the law made by the center will prevail. So this shows the example of Dr. B.R. Ambedkar's definition. So here the center has power to override the power of state legislature. Okay. So these are the two definitions of two scholars. One is Professor K.C. Veras and second is Dr. B.R. Ambedkar. Okay. So the next is कि कौन से करेक्टरिस्टिक्स हैं जो बताते हैं कि फेडरल है। द कॉन्स्टिट्यूशन ऑफ इंडिया फेडरल, सो देयर आर सर्टेन फीचर व्हिच आर एसेंशियल टू बी प्रेजेंट इन द फेडरल कॉन्स्टिट्यूशन। सो फेडरलिज्म मींस होता क्या है, फेडरलिज्म मींस द डिवीजन ऑफ पावर्स, पावर्स को क्या डिवीजन करना, पावर को डिवाइड करके, जैसे अभी एग्जांपल दे देते हैं हम शेड्यूल 7 का, शेड्यूल 7 में क्या डिवीजन किया हुआ है, यूनियन लेजिस्लेशन लॉ बनाएगा और स्टेट लिस्ट के लिए स्टेट लेजिस्लेशन लॉ बनाएगा, ठीक है। तो द सेंटर एंड द स्टेट आर नॉट सबऑर्डिनेट बट कोऑर्डिनेट विद ईच अदर, they work independently in their own sphere. In other words, it seeks to bring unity in diversity and the achievement of common national goals. All these means all these things, either center makes the law or state legislation makes the law, but the condition is these laws in the interest of nations. These laws are in the interest of nation, in unity in diversity and achievement of common national goals. वो देश से बाहर नहीं होने चाहिए। Prevention as well as a settlement of conflict of the interest of the center and the state is an important part of the federalism. So this is the reason why the Indian federalism was devised with a strong center. So then the Constitution of India has adopted federal feature, though it is not a complete federal nation. So there are, we can say that there are some provisions in our constitution, but the Indian is not a federal state like as US. Okay. So what are the essential characters? There are four characters, sorry 5 characters. Number 1 is supremacy of law. Supremacy of law. Second, distribution of powers. जो अभी हम डिस्कस कर रहे थे। थर्ड है हमारा रिटन कॉन्स्टिट्यूशन, फोर्थ है रिजिडिटी एंड फिफ्थ है अथॉरिटी ऑफ फोर्स। सो व्हाट डू यू मीन बाय सुप्रीमेसी ऑफ लॉ? सुप्रीमेसी ऑफ लॉ मींस द कॉन्स्टिट्यूशन इज द सुप्रीम लॉ, no law is above the supreme law, sorry, above the constitution of India, ठीक है। So what is the when we are talking about the constitution supreme law, so first of all we have to know what is law. So law involves rules regulation, जैसे कि आर्टिकल 30 क्लॉज 1 में पढ़ा हुआ है कि लॉ क्या होता है। तो 30 आर्टिकल 13 क्लॉज 1 says that laws include any rules, any regulations, any bylaws, any notification, orders, ordinances, and even the custom which having a force of law. Custom is also a sources of law, as we have already discussed in jurisprudence. So custom is also a law. It is also a main source of law. Custom, precedent, and legislation. So these are the laws. ठीक है. So any rules, any regulations, any bylaws, any notification, any orders, any ordinances, and custom also cannot be the override the Constitution of India. We can say that the Constitution is the Constitution of India is the root of any law. सो सुप्रीमेसी ऑफ लॉ के लिए जब हम बात करते हैं तो हमारा प्रोविजन दिया हुआ कॉन्स्टिट्यूशन ऑफ इंडिया में आर्टिकल 13 क्लॉज 2 में. आर्टिकल 13 क्लॉज 2 का क्या बोलता है? द स्टेट शैल नॉट मेक एनी लॉ विच टेक्स अवे. राज्य कोई भी ऐसा कानून नहीं बनाएगा कैसा कि विच टेक्स अवे एनी ऑफ द राइट्स गारंटेड अंडर Part 3 of Indian Constitution, and to the extent of such contravention, the law is considered void. So this shows the supremacy of Constitution of India and supremacy of law. So Article 32 clearly says that state कोई भी ऐसा law नहीं बनाएगा. State means not talking about any state of India. It takes about the legislatures. ठीक है. So no legislature shall make any law which takes away any of the rights guaranteed under Part 3 of the Indian Constitution. अब Part 3 की बात करते हैं. Part 3 में क्या दिया हुआ है हमको? फंडामेंटल राइट्स. फंडामेंटल राइट्स हमारे मूलभूत अधिकार. कोई भी सरकार ऐसा कोई भी कानून नहीं बनाएगी जो संविधान भारतीय संविधान के भाग 3 में मूलभूत अधिकार दिए हैं उनको उस लॉ के द्वारा उसको छीना जाए. ठीक है. ऐसा कोई भी लॉ नहीं बनाएगी. यदि कोई ऐसा सरकार कोई लॉ बनाती है, ऐसा कोई भी रूल्स बनाती है, ऐसा कोई भी नोटिफिकेशन ऑर्डर्स whichever is included in the laws, so this law is considered void. वो law क्या माना जाएगा? Void. Now the question comes that to what extent it to be void. So it is void to the extent of such contravention. जितना वो कंट्रावेन कर रहा है, किसमें कंट्रावेन कर रहा है? हमारे फंडामेंटल राइट्स. तो उस पीरियड तक उस एक्सटेंट तक क्या है वो वॉइड माना जाएगा, अदरवाइज वो वैलिड होगा. ठीक है. सो दिस इज अबाउट द सुप्रीमेसी ऑफ लॉ. ठीक है. नाउ द सेकंड इज डिस्ट्रीब्यूशन ऑफ पावर. सो वी हैव ऑलरेडी डिस्कस्ड विद द डेफिनेशंस इन पार्ट. देयर इज टू in the 7th schedule there is 3 lists. One is union list, second is state list, and third is concurrent list. And there are some entries for particular legislature, and they can make the laws for their respective areas. So this is the distribution of power in regard of legislation or law. Third is written constitution. So if federal constitution must be written, हमारा भारत का जो संविधान है written में है. So this shows that it is a federal constitution. Since the federal nature of the constitution involve a lot of contracts, hence it would be impractical not to have these written forever to maintain the supremacy of constitution. So it is imperative to have a written constitution. तो हमारा भारत के संविधान में written constitution. बहुत सारे कंट्रीज ऐसे जैसे यूके है. यूके का जो कॉन्स्टिट्यूशन है वो रिटन नहीं है. द यूनाइटेड किंगडम डज नॉट हैव अ रिटन कॉन्स्टिट्यूशन and therefore it is not regarded as a federal country. The state and a federal system come together and enter into a treaty, and the terms of the treaty are required to be in writing in the form of a written constitution. क्योंकि कोई भी देश है इंटरनेशनल लेवल पे उसका क्या है, उसको फेडरल हम तब मानेंगे जब उसका रिटन कॉन्स्टिट्यूशन. बिकॉज कि इंटरनेशनल लेवल पे चाहे बिजनेस पर्पज से हो, चाहे पॉलिटिकल पर्पज से हो, MOUs वगैरह हो, तो क्या या फिर कॉन्ट्रैक्ट्स करने हो, तो वो कॉन्ट्रैक्ट कब होगा? जब उसके संविधान में लिखा होगा, जब उसका संविधान उसको परमिट कर रहा होगा. तो यूके के साथ ऐसा नहीं है कि हमारा इंडियन कॉन्स्टिट्यूशन रिटन है. तो there is no denial of the fact that a written constitution brings stability in the overall governance of the country. If there were no written constitution defining the scope of the powers of the center and the state, there will be a chaos and confusion. So, moreover, misunderstanding and conflict will arise between the center and the state, who would seek to cross over each other's authority. तो वहाँ पर क्या है, बहुत ज़्यादा कंफ्यूजन हो जाएगा, पावर डिवाइडेड नहीं है, डिवीजन ऑफ पावर्स नहीं है, कॉन्स्टिट्यूशन रिटन नहीं है, वहाँ पर कुछ लिखा नहीं है कि स्टेट लेजिस्लेचर किस पार्ट पे लॉ बनाएगा, सेंट्रल लेजिस्लेचर किस पार्ट पे लॉ बनाएगा. तो वहाँ पर क्या है, एक कंफ्यूजन पैदा होगा और इससे क्या है कि बहुत सारा चोज होगा. ठीक है, और वहाँ पे बहुत ज़्यादा पॉसिबिलिटी होगी कि एक दूसरे यूनियन भी और सेंटर भी एक दूसरे पावर को इनक्रोच करें. ठीक है, so written constitution is also the features of federalism. Now the fourth is rigidity. ठीक है, so the constitution should be rigid and permanent. Constitution क्या है, rigid होना चाहिए और permanent. A lousy set of document cannot be set to a federal constitution. The method of amendment should be rigid, otherwise the basic principle of the constitution would be under threat. ठीक है, for example, for defining the features and natures of the constitution, there are 4-5 landmark judgment. Sankarnath, Sajjan Prasad, Golaknath, and Keshavananda Bharti. So after a period of 20 or 22 years, the nature of the constitution is defined. Or the preamble is part or not. And every very case also involves this method. So the method of amendment should be rigid. वो rigid होना चाहिए. ठीक है, otherwise the basic principle of the constitution would be under threat. However, the rigidness of the constitution should not be confused with the inflexibility. The constitution is an organic document and should be flexible enough to accommodate according to the changing times. जैसे जैसे समय परिवर्तन हो रहा है उसके साथ साथ क्या है, अमेंडमेंट भी होने चाहिए. ठीक है, ऐसा नहीं है कि आप इतना रिजिड कर दो कि आप हम समय के साथ नहीं चल पाए. हम यदि समय के साथ अमेंडमेंट नहीं करेंगे अपने जो भी हमारा लॉ है, कॉन्स्टिट्यूशन है, तो क्या है, हम जो दुनिया से क्या पीछे रह जाएंगे, हम अपने लोगों को क्या है जस्टिस नहीं दिला पाएंगे. सो विद द चेंजिंग टाइम्स इट accommodate according to the situations. Now the fifth is authority of courts. So the judiciary has the final authority to interpret the institution. So who can interpret the constitution? Judiciary. And who is the guardian of the constitution? The Supreme Court of India. The guardian of the constitution is Supreme Court of India, which is supreme in all courts. So the rationale for this provision is that only an independent tribunal which is authorized to resolve dispute between the center and the state could impartially resolve all the dispute between the center and the state government. So in the Constitution of India, the authority is given to the courts to interpret the constitution. The reason is that independence of judiciary. If judiciary is independent, then he can resolve the dispute between the center and the state impartially. And if judiciary is not independent, then this thing cannot be possible. The biasness can involve. So independence of judiciary gives the authority to the courts to interpret the constitution. So in regards of India, the Supreme Court is that federal court which has such power and competency. So Supreme Court को हमने power दे रखी है. ठीक है, Supreme Court को हम guardian मानते हैं Constitution of India का. And the Supreme Court is authorized to exercise such power by way of Article 131 of the Indian Constitution. So Article 131 क्या है, क्या बताता है हमारा, कि original jurisdiction के लिए. When we are talking about the jurisdiction of Supreme Court, so Supreme Court have jurisdiction only in original jurisdiction only in certain matters only. So what are the matters? The matters are when the case is between the two states. Second, when the case between the one side is the state and other side is your center. And third, one side is one or more state and other and center. So, however, for solving the interstate water dispute, the parliament has to create an ad hoc tribunal to resolve a dispute, specific water dispute between two states. For example, there is Kaveri water dispute, which is dealing with the water dispute between Kerala, Karnataka, and Tamil Nadu. केरला कर्नाटका एक साइड थे, तमिलनाडु अदर साइड. तीन स्टेट के बीच में डिस्प्यूट था. डिस्प्यूट गया सुप्रीम कोर्ट में. सुप्रीम कोर्ट के ओरिजिनल जुरिस्डिक्शन में, तो सुप्रीम कोर्ट ने उसको सुना. सो दिस पावर गिवन टू द सेंट्रल गवर्नमेंट टू क्रिएट ए सेपरेट ट्रिब्यूनल इज ऑल्दो स्मॉल बट सिग्निफिकेंट यूनिटरी फीचर. द Ragadan border dispute case pending is in Supreme Court. The Bedgaon, sorry. सो इट इज बिटवीन, ये बेड़गांव वाला है, ये किस किस के बीच में था? महाराष्ट्र और कर्नाटक के बीच में. तो इस केस में क्या हुआ था? महाराष्ट्र ने क्लेम किया था दैट द मेजॉरिटी ऑफ द पीपल इन दैट रीजन आर मराठी स्पीकिंग. वो मराठी बोलते हैं उसके जो बेड़गांव वाला रीजन है. सो द रीजन शुड बी बिलोंग टू देम व्हाइल द कर्नाटक डिमांड दैट द ऑपोजिट. कर्नाटक क्या बोल रहा है? वो कन्नड़ बोल रहे हैं. ठीक है. तो डिस्प्यूट क्या था? वो टेरिटरी को लेकर था कि इस टेरिटरी में यदि हम लिंग्विस्टिक बेस पे देखें तो वहाँ पे महाराष्ट्र बोल रहा है कि मराठी बोल रहे हैं तो ये हमारा एरिया, हमारे लोग हैं. कर्नाटक बोल रहा है, कन्नड़ बोल रहे हैं, हमारा एरिया, हमारे लोग. सो दस एन इंडिपेंडेंट जुडिशियल कोर्ट इज वेरी नेसेसरी फेडरल फीचर ऑफ द कॉन्स्टिट्यूशन. ठीक है. आई थिंक इट वुड बी क्लियर टू ऑल ऑफ यू. सो these are the 5 essential characteristics of a federal constitution. One is supremacy of law. Second is distribution of powers between center and state. Third is written constitution. India have a written constitution. Fourth is rigidity. And fifth is authority of courts. Independence of judiciary. So this is all about the nature of the Indian constitution, which is quasi-federal. It has both symptoms. Unitary and federal also. Now next topic is salient features of the Constitution of India. So this is very more interesting topic, salient features. So what will be the salient features of the Constitution of India? So all of us knows that the Constitution of India, which commences fully commenced from 26 January 1950. So the Constitution of India has been successfully guiding the path and progress of India. So the features, first is written and detailed Constitution. So we have already discussed about the written Constitution. So what is detailed Constitution? So detailed Constitution means what it contains. What the Constitution of India contains. So it consists of 395 articles, which is divided into 20 parts and having 12 schedules and having I think 107 amendments also. Okay. So Constitution of India is consisting of 395 articles in 20 parts and 12 schedules. Second is self-made and enacted constitution. Self-made means हमारे भारत के लोगों ने बनाया. एक कॉन्स्टिट्यूशन कमेटी थी जिसमें बहुत सारी कमेटियां थी इंटरनल, जैसे ड्राफ्टिंग कमेटी, जिसके चेयरमैन डॉक्टर B.R. अम्बेडकर थे. So Indian Constitution is a constitution which is made by the people of India acting through their duly elected and representative The assembly was organized in December 1946 और इसका जो फर्स्ट सेशन है वो कब हुआ था 9th December 1946 को. It passed the objective resolutions on 22nd January 1947. Thereafter, it initiated the process of constitution making in the right earnest and was in position to finally pass and adopt the constitution on 26th November 1949, which is also known as the Law Day, which is celebrated as the Law Day in the whole territory of India. Okay? The constitution became fully operational with effect from 26 जनवरी 1950 से आया और उस डे को हम किस डे के रूप में मनाते हैं? रिपब्लिक डे. ठीक है, तो हम कह सकते हैं कि कॉन्स्टिट्यूशन ऑफ इंडिया क्या है? सेल्फ मेड है और इनेक्टेड है. ठीक है. थर्ड इज प्रीएम्बल ऑफ द कॉन्स्टिट्यूशन. दिस इज वेरी इंटरेस्टिंग and this shows the face of the constitution of India. प्रीएम्बल एक ऐसा पार्ट है जो ये बता देता है कि कॉन्स्टिट्यूशन ऑफ इंडिया क्या है. नॉट ओनली द ड्राफ्ट, not only talking about the books, it shows the constitution of whole India. भारत का संरचनात्मक, संगठनात्मक, राजनीतिक कैसे है. ठीक है, जुडिशरी क्या हो, तो भारत का कैसे कॉन्स्टिट्यूशन है. ठीक है, तो वो हम बोलते हैं प्रेमा फेसाई, वो हम प्रेमा फेसाई हमको प्रीएम्बल से ही पता चल जाता है. ठीक है, तो प्रीएम्बल हमारा क्या है? वी द पीपल ऑफ इंडिया हैव solemnly resolved to constitute India into a secular, socialistic, democratic एंड रिपब्लिक. हम भारत के सभी लोग इंडिया को सेक्युलर, सोशलिस्टिक, रिपब्लिक और डेमोक्रेटिक इंडिया भारत बनाना चाहते हैं. ठीक है, एंड नाउ फोर्थ इज इंडिया इज हम बोलेंगे डेमोक्रेटिक सोशलिस्टिक स्टेट. So, although right from the beginning of the Indian Constitution fully reflected the spirit of democratic socialism, so in the 1976 there is a huge amendment in the Constitution of India. So, this Amendment Act 1976 is also called the Mini Constitution of India. So, this says that the preamble was amended to include the term socialism. It is now regarded as a prime feature of the Indian state. So India is committed to secure social, economic and political justice for its entire people by ending all form of exploitation. So it says that India secures social, economic and political justice. So what is economic justice? Economic justice means there is no gap between the rich and poor. There is no bridge between the rich and poor. गरीब और अमीर के बीच में कोई फर्क नहीं होना चाहिए. ठीक है, नो सोशल जस्टिस होना चाहिए. ठीक है, जाति धर्म के बेस पर कोई भेदभाव नहीं करेगा. पॉलिटिकल जस्टिस होना चाहिए. ठीक है, जिससे कि सारे मतलब किसी भी रूप से किसी भी व्यक्ति का भारत के अंदर एक्सप्लॉयटेशन नहीं हो सके. एंड बाय सिक्योरिंग इक्विटेबल डिस्ट्रीब्यूशन ऑफ इनकम, रिसोर्सेज एंड वेल्थ. कंट्रीज के जितने भी रिसोर्सेज हैं, इनकम है, वेल्थ है, सबके क्या है? भारत हर लोग का अधिकार है. बट जनरली these thing can not also implement till they. और आज भी बहुत सारी घटना देश के किसी भी हिस्से से सुनने में आ जाती हैं सोशल जस्टिस को लेके. कहीं पे धर्म के नाम पे हो रहा है, कहीं पे जाति के नाम पे हो रहा है, कहीं पे गरीब अमीर को खा रहा है. ठीक है, so all these things cannot be done. It will be stopped. So this is to be secured by the peaceful, constitutional and democratic means. Now fifth is India is a secular state. So India एक secular state है. Secular state means respect for all religions. Respect for all religions. So India gives special status that no religion. भारत में कोई religion नहीं होगा. All are Indians. We all are Indians. So there is no such thing as a state religion of India. This makes it different from theocratic state like the Islamic Republic of Pakistan or other Islamic countries. ठीक है, जैसा कि और इस्लामिक कंट्रीज है वहाँ पे इस्लाम हो गया है. For the Indian secularism guarantees equal freedom to all religions. So the Constitution grants the right to religious freedom to all the citizens, and it is also included in the fundamental rights. Article 26 to Article 28 gives the fundamental rights to the people to profess and propagate the religion of his choice. When we are talking about the democracy of India, so India is a democratic state. The authority of the government rests upon the sovereignty of the people. People are sovereign, not the government. Okay? So the people enjoy equal political rights. On the basis of these rights, the people freely participate in the process of politics. They elect their government. वो सिस्टम नहीं है कि राजा का बेटा ही राजा होगा. ठीक है. So free, fair and regular election are held for the हर 5 साल के बाद आम चुनाव होता है. ठीक है, लोग अपना रिप्रेजेंटेटिव चुनते हैं. रिप्रेजेंटेटिव लोकसभा में जाता है. ठीक है, तो ठीक है, डेमोक्रेसी को शो करता है. So for all its activities, the government of India is responsible before the people. The people can change their government through elections. No government can remain in power which does not enjoy confidence of the people. तो हमारे यहाँ पे क्या है, बहुमत का सिस्टम है. जिसके पास बहुमत है उसकी सरकार रहेगी. ठीक है. Now next is India is a republic. So India is a republican country. ठीक है. The preamble declares India to be a republic. So India is not ruled by a monarch or a nominated head of the state. So India had an elected head of the state, which is called as President of India. And there is a fixed term for the President of India for 5 years. After every 5 years, the people of India indirectly elect their president. So the word using here is indirectly, not the people directly elect the president. Indirectly means the representative which is elected by the people of India elect the president of India. Okay? So this shows the republic characteristics of the Constitution of India. So this is all about the nature of the Indian Constitution and salient features of the Constitution of India. So when we are talking about the salient features, the Constitution of India is a written document and detailed constitution which having 395 articles, 22 parts, 12 schedules. It is self-made. The committee is framed by the government of India to make the constitution. An enacted constitution which is enacted on 26th November 1949, which is observed as the Law Day, and it fully commenced from the 26th January 1950, which is celebrated as the Republic Day of India. And there is a preamble of the Constitution of India which shows the phases of the Constitution of India. It says that the Constitution of India is a secular state, socialistic state, republic, democratic, and its guarantees the social justice, social justice, economic justice, and political justice. So this is all about the salient features of the Constitution of India. I think it would be very clear to all of you. If you are having any doubt, so you can comment in the, you can paste the comment in box.